Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court, from recess, now sits.
Please be seated. We'll call the next case on the morning docket 102297, State of Kansas versus Pamela Hall. Counsel?
May it please the Court, the appellee, State of Kansas, appears by Stephen Obermeyer. Justice Lukert, if I may reserve 2 minutes, please.
Yes, 2 minutes is reserved.
Thank you. For the benefit of the students, I know the Court knows the facts, but basically we have a theft from a veterinary clinic by an employee who worked there and took a lot of items from the clinic. So the issue that the Court of Appeals addressed was what is the restitution for those items, what is the value for those items, and we know that sentencing courts have considerable discretion in determining the amount of restitution, and the usual standard is to look at the fair market value of the item. One of the items taken was a gentle leader, and if you have a chow mix or a lab like I do that doesn't like your pace, one of these items is helpful. And one of these items is a replica of what was stolen, so in an unabashed display of product placement, I will tell the court that in deciding what the value of this item is, how do we do that? And it kind of depends on where you are. If I'm in a retail store, I would look at the price tag. And if I've asked these students, do you think the value of this is what's on the price tag for restitution, I think they'd agree. But the Court of Appeals says, no, you
Value
can't.
to whom? Value to whom? The store bought that at wholesale value.
Correct.
And when you talk about fair market value being a willing buyer and a willing seller, there again you have to identify who are the seller and the buyers. The retailer is selling to the public, but with respect to their inventory, they bought it from a supplier. So you have a wholesaler being the seller and the retailer being the buyer to put it into inventory, correct?
Correct.
So just saying it's fair market value doesn't help us any. We have to identify who the seller and the buyers are. Fair market value to whom? Fair market value to the purchaser is what they have to pay for it, but to the merchant, isn't it what the merchant had to pay for it? Isn't that what they lost?
I think I'd look at it as what the person who shoplifted it, what it was worth to them that they decided not to pay for it, so I'm going to take it. And I think this is my essential disagreement with the Court of Appeals in State versus Hall. We talk about you have to use the fair market value of what a willing buyer and willing seller would have in an arm's length transaction, but whose market? And the Court of Appeals says the relevant seller and buyer are the wholesalers or the vendors of the inventory and the clinic, that's the market that we're looking at. And I think our contention is when you have a theft of retail merchandise, that it's not an abuse of discretion to make it the retail value of the item. Now, if Hall, the defendant, stole while working at a wholesaler business, then I think that would change, and it could be the wholesale value of the price. Or at the factory where they make the gentle leader, maybe that's a different amount.
Let's throw another thing in there.
Okay.
Say it's not inventory, but it's supplies. Say this vet boards animals, and so they use that particular item to walk the animals they're boarding. And I understood that some of the things here were used as supplies. In other words, the vet used the syringes to give shots, but also sold to others. And wouldn't you agree that if it's a supply, it's really a stretch to get to the retail price?
Yes, I think it would be different. And I don't recall, I don't know if the value of the syringes was actually assessed as restitution or not. But it would be different if they were just using that as a supply, and it wouldn't be new where somebody would just buy that. If I tried to sell this to somebody, I've been using it, I'm not going to get the amount that.
No, that's not my point. If it's sitting on the shelf and is brand new, but its intended use is to be used in the clinic, then it's a supply. And I can understand the argument that the retailer has lost the profit when the items have been stolen, and they shouldn't be denied that. But if it was intended to be used as a supply, then they never intended to have or would never have gotten the profit. So it's more difficult to say that it's not an abuse of discretion to add profit on something that would never have been obtained. Do you understand what I'm saying?
Yes, I think I'd agree. If it was a supply, you look at what it was worth to the
Or do you look at what
veterinary-
you would charge the client?
I'm sorry?
Or do you look at what you would charge the client? I mean, if we, to be cynical, when we get a medical bill and you look on there and you see $10 for 2 aspirin,
Right.
Kind of thing, you know there's a markup going on there as well to cover their costs of doing business. So which is it, the cost to the veterinarian, or is it what the veterinarian might charge the client?
I think for theft of retail items, it'd be what they would have charged the client. Now, if there was an employee discount, then maybe that's what the restitution should be. And that's why we say there's substantial discretion to the courts on this. And if a court says, I think $10 for 2 aspirin is too much, they can have the discretion to go lower than that.
I want to differentiate because I'm not sure I think you're clear in your answers. I'm not sure that if we compare what was the dialogue here that it comes across. You're saying that if the victim of the crime would have been able to receive a profit off of the item, that the judge should consider the profit that they would have gotten from that item, because that would be either Justice Lukert's question about charging a markup. That's the same thing as selling it off the shelf. But the supply question, as I understood it from Justice Johnson, was if they boarded animals and they fed them and they don't charge the client any more for the food, it's part of the base cost, then there you don't have a profit easily distinguishable, so it's just part of their operations. They don't charge any more to the patient or the client because they do something. Then there it's closer to a wholesale value. Is that right? I mean, am I understanding what you're saying correct?
Yes, I think that's what I'm saying is you kind of look at what the victim owner's use of that property, what that was for, and what its fair market value is. If it's just a supply for walking the dogs, or like a used leash, you're not going to get what it costs them. And there's a lot of cases where victim doesn't know what my property was worth. The court assesses fair market value to buy a new one, and the appellate courts say, no, you can't impose that. You have to impose what it was worth at the time it was stolen. So supplies...
Let me follow up on that.
Okay.
Sure. I understand your point about profit, but I'm wondering about some other factors that might affect what's the true fair market value of an item that's been taken. For example, let's say it's syringes in you have 20 syringes in a box or something. I don't know how they sell syringes, but they're completely fungible and easily replaceable at the wholesale cost. Not a unique item, not something that might have some particularized overhead attached to it or some other cost. Just you can call up the supplier and say, I need another box of 20, and it's going to cost you exactly what it cost you when you bought it 3 weeks ago before the theft. Should that have some impact? When you've got a completely fungible item. My reading of the materials in this case indicated there was some sort of limitation on ability to reorder. Do you remember what that evidence is about, and should that have some effect?
I remember the part about the syringes.
I'm just using those as an example.
I don't remember what the limitation was.
I mean, there could be, for example, there could be a market operating so that something was worth more later or worth less later. The tulip bulb thing, in Holland. I mean,
Right.
eventually they just weren't worth anything, even though they were quite valuable at one time. But that's not the situation we have here. We have a bunch of stuff that the vet clinic buys from a supplier, and they can just call up the next day and buy it again. So aren't they really
Correct.
fully compensated when they get the money to buy it again?
I think as to the supplies, that would be what the value.
But they can sell those and get the profit that you're saying they should be able to get from the thief. I mean, if they're completely fungible and they can turn right around and sell them for exactly the markup they were going to sell them for before, and there's no limit to the supply. It's not again, it's a fungible, ready supply. I'm just trying to understand why they should be able to get the profit.
And they haven't lost any sales.
Haven't lost any sales because it's immediately replaceable. I don't know that
Right.
these are the facts of this case. I grant you that. It just seems to me that all of these things, this whole range of things, are amenable to proof at the hearing. And the state can get energetic and put on a bunch of evidence about it, and then the defense can get energetic about cross-examining or putting on its own evidence to combat the figure. And isn't that just where we should leave it? The statute's broad.
Yes.
Everything caused by the crime, right?
Correct.
And then we've always said in all these cases that have tried to pick this apart that the district judge has quite a bit of discretion. That's where you started today.
Correct.
So isn't all of this just subject to proof and argument?
Yes.
It doesn't just
I
saying
think it
you have
is.
to get to fair market value kind of oversimplify what that proof may look like? Because I think timing, I think market, I think fungibility of the goods, et cetera, I think those are all factors here.
I agree. I do think they're all
Okay.
factors. And there was evidence presented by one of the owners of the veterinary clinic that this is the fair market value of these items that were taken. And there were some items, I think actually there were 3 of these that people wanted to buy, but we don't have any in our inventory because the defendant stole them.
So that might be a lost sale.
Yes.
Yeah.
But loss of goodwill, I mean, where does it end?
Well,
Too
Have some pretty
speculative?
lengthy hearings.
I mean,
yeah. Then you get into the connection between that. There's a case where a victim is burglarized, gets a home security system installed, and they say that's not really related. Yeah.
Well, and that's
So
the
is
challenge.
causation, I'm sorry, so is causation the only factor? Only parameter that we use for limitation?
Could you give me an example?
Well, I mean, are we just going to, would the decision of this court be just go forth, district court, and use your discretion without limitation? Or are there some parameters on that limitation beyond causation, which is stated in the statute?
I think on the cases where there have been reversals, the issues have been the fair market value, that it's not related to the loss, like the security system. There's a case involving scaffolding that you can't use the new price of it. You have to figure out what it was worth at the time it was stolen. I think it goes back to that's why we give trial court substantial discretion on these different items, and if it's an individual selling something, it has a different value, fair market value, if you had to sell that in an arm's length transaction, than that if it's in the store and has the price tag on it and take it. And that is kind of...
We do have some case law that won't allow speculative damages. And if you had an item that is if I had a bunch of pink flamingos, maybe I couldn't sell those. And it might be speculative that I could make a profit on them because you have to sell them first. So it would seem like that would be one of the constraints in addition to causation, wouldn't it? Or is that just part of causation?
I think you could look at the speculative, but as an owner of the pink flamingos, you could give your opinion as to what it's worth. Whether the sentencing court wants to agree with that or not is another issue. And some issues, I know there's a case where there's women's lingerie that's stolen that was used, and it's like we have no idea what the restitution is on that. So they gave the replacement value, and that's probably one of the few cases where you see that. But I think the majority rule in other jurisdictions, and I cited a lot of cases in page 5 of the petition for review, is that you can allow for retail value, and state versus Davis that I did the 609 letter on also discusses that.
On the record in this case, what do you think indicates that the district court took all these different factors into consideration in coming up with the award? Or did the district court just use a hard and fast rule, sort of like, you're here arguing against the Court of Appeals hard and fast rule, but I'm just getting back to the district court. What do you think demonstrates that the court took in the different things that have been talked about here in coming up with?
The district court heard evidence as to the retail value of these items and the cost of some of those items. There were some treatments to the defendant had 2 pets, and the clinic was trying to bill what it would bill a customer for that, as opposed to the lesser amount that I think an employee would get. And so Judge Davis disallowed some of that restitution in making the finding, and as far as the retail items, went with what it would cost to walk out of the clinic with those. So I think there was some balancing and weighing of that in coming at that amount. Thank you.
May it please the court, I'm Heather Sussman with the Appellate Defender Office here on behalf of the defendant, Ms. Pamela Hall. And I actually don't think the state and I and the Court of Appeals are terribly far apart on this. Really, I think Justice Johnson and Justice Beyer, I think the 2 key words were ones that you used, which is proof and basically proof and causation. And the problem here is that, and I think if you reread the restitution hearing statements from the judge made a blanket statement and said, look, this is a retailer, this veterinary clinic sold these items, this is a retailer, and we're going to get retail value because basically that prevents any business from being able to get some kind of profit from these sales. It wasn't based on, and I will say, I think Mr. Obermeyer was right when he said that there were about $70 worth of items that the defense counsel even stipulated at the restitution hearing that Ms. Harden had properly submitted proof that they had had somebody come in and had not been able to make the sale. And defense counsel said below, we're not objecting to that. That's fine. It's the rest of this that they haven't put on evidence of what your lost profits are. And so our argument on appeal has been twofold, and I think what the Court of Appeals did was to say, look, just because you're a retailer doesn't mean that you're automatically going to get the retail price, because the retail price does include a profit margin. And so if you have inventory that's stolen, then your restitution is going to be based on what it costs to essentially replace that inventory, which in this case would be the wholesale cost. And if you don't think that that reflects the fair market value because you have some kind of proof of lost profits, then you can put that on and try to make that case. But you have to be able to put that on. And I think the record in this case makes it clear that they did not do that for the most part. And so our argument is not that there's some broad statement by the Court of Appeals in this opinion that says that retailers never get the retail value. What I think the Court of Appeals says is that if you're going to ask for the retail value, it's not automatic, and you're going to have to put on some kind of a proof to support that. And I think that's as far as the Court of Appeals' opinion in this case goes, and we would support that.
So your argument's really more of there was not substantial competent evidence to support the district court's award. Right.
Well, and I will say our argument is twofold. I think the district court did err on the legal analysis of assuming that a retailer gets retail value as the fair market value. So I think the judge made a blanket statement, and I think we need direction from this court as to whether or not that's a sort of blanket assumption, or whether or not, depending on who the buyer and the seller are, you have to determine, is this inventory cost, wholesale cost, or is this retail value? So I think there's a legal problem here as to what the district court judge did. But then our second part of that argument is, to the extent that the state might be able to prove that there were lost retail costs or lost profits that they might have been able to ask for, they didn't do so in this case. They didn't put on enough proof of that in this case.
You're conceding that some defendants may properly have to pay restitution for someone's lost profits.
I think that's what the defense attorney below argued as well. I mean, they conceded that point on the $70 that they were able to put on evidence to say, look, there was actually somebody in our store who was going to buy this, and we had to turn them away. I mean, I think defense counsel below even acknowledged that that's properly there. But the question is whether or not that's automatic without that proof, and then what it takes to prove it. And really, I think this is based on the fact that if you have inventory, if you're a retailer and you have inventory, you're not selling out of your inventory completely at the end of every day. You're going to have stuff that's still left on those shelves that's not necessarily profit that you've lost because that item wasn't there until you replaced it 2 days later just because my client walked out of the store with it improperly. And because we have all these cases that say that you have to have non-speculative costs associated with the restitution, you can't just assume that somebody would have come in and bought. There has to be some kind of proof. And we're not saying that there has to be mathematical certainty or that you have to be able to present the name and social security number of the people who were turned away necessarily, but you have to have some kind of evidence. And just a blanket statement that you're a retailer, so your fair market value is retail cost is, I think, simplifying it to the point of giving a windfall to the retailer in a case where they haven't been able to prove that they deserve it.
I'm sorry to be thick about this. I don't see the legal question. You're conceding that profits can be part of the mix. Then aren't you really just saying that there weren't sufficient facts to support the award of profits, as opposed to the law does not permit the assessment of profit?
I think our legal argument is that the law does not automatically require a retailer to get retail value, which I think is part of what sort of is underlying the argument on the state on a lot of this when you go through and you read what happened at the restitution hearing and then the briefs that were filed. So to the extent that that is a legal question as to whether or not you automatically get that as a retailer versus automatically get wholesale because you're a wholesaler, that's what I'm saying is our legal question. If I'm not answering
and then you're talking about proofs secondarily.
Right.
You're just saying it shouldn't be automatic either direction.
Right.
It's all subject to proof.
Right.
Everybody comes in, fires away.
Right. And
Judge decides. You don't think the district court did that?
I don't think the district court did, and I think
the
his
Court of
statements
Appeals came closer.
I'm sorry?
You think the Court of Appeals came closer?
I think
to
the Court
doing
of
what you're
Appeals
suggesting,
came
but
closer.
You would argue that. We'd expect that,
Yeah.
given the circumstances. And then you're talking about proof. You're saying
Right.
Once we get the legal rule right, we need to look at the proof.
Right. And I mean, and I think the legal rule is what we've said over and over again in these cases, which is that it's the actual loss. It's the actual loss that's sustained, and the actual loss is not automatically going to include profits in a situation where you can't prove that you actually lost profits on that. So
How do you? Go ahead.
Go ahead. Isn't there something in between? I mean, if I'm a merchant and I order in merchandise, the cost of that merchandise is just a starting point for my cost. I have to pay employees to, stock the shelf, to do, all of those other things. Even if I don't do a sale, there is a cost of doing business associated with stocking the merchandise. And so, and usually that's part of the profit, built into whatever you will charge a customer. But I agree, then there's probably beyond that a percentage that's just pure profit. So how do we, and that's going to be something that's very difficult to prove on a item-by-item basis. But don't we allow a merchant more than just that pure merchandise cost?
well, and I guess that's the I think that's where it's going to come down for the district court to in case-by-case basis on proof, because and I will say the on the standard of proof for the district court, this is an abuse of discretion standard on that part of the question. And so to the extent that if the judge feels that they've put on sufficient evidence that they would not have had to spend the money on the personnel to restock for that many hours because they wouldn't normally have had that inventory shipment because that wasn't a normal inventory shipment. It was an inventory shipment, for instance, that came in specifically because they were replacing. I mean, I think you can put on something there to support that, and then it would be a question of whether or not the judge abused his discretion on the proof aspect of that. But I think that still has to be some sort of proof if you're asking for that above and beyond what it costs for your wholesale cost in a situation where you're talking about inventory.
And you don't think we can just shortcut that? Since, I mean, because of the difficulties of proof?
Well, and I mean, I guess but your profit is not necessarily going to only include what it costs, for instance, to restock the shelves. I mean, you're also potentially trying to make a profit above that. So I guess that's what our problem with this idea of just saying retail, if you're a retailer, you get retail value. I think that's where we get into trouble, is because I don't think that your retail cost above your wholesale cost is just about paying your employees extra in order to restock, or I mean, I think it's also goes above and beyond that. And if you're not actually missing out sales because that item's not on your shelves, then I think you're requiring the defendant to be responsible for something that's not actually a result of is not an actual loss as a result of their crime.
Tangential, we're back to that.
Yeah.
And if it's a matter of proof, why should it be the victim that has to prove that they've got more than the wholesale loss? If we recognize that that's a fairly common expense to restock, a lot of places you can return an item, but they'll charge you a restocking fee. Mm-hmm. So obviously we know that, and if someone's going to have to bear the burden, why shouldn't it be the culprit rather than the victim? And in that case, we would start with the retail price and leave it to the defendant to show that the particular victim has not really suffered that loss.
I think I think the most obvious answer to the question here that you've asked is that to put the defendant in the position of having to prove something that's really in the whole control of to put the defendant in the position of having to prove something that's in the whole control of the victim puts the defendant in a sort of untenable position. I mean, how is my client supposed to prove that, they didn't really spend that many hours with their employees restocking? I mean, that's part of the reason why we require, if the victim's going to be asking for this money above and beyond just the mere conviction as part of the restitution, then their burden's on them because they're the ones basically that have the information to be able to prove it. So, I mean, I think the realistic answer is that if you were requiring my client to basically turn that around and prove that they're not entitled to the restitution, I think you would have a real big problem with how the defendant's supposed to be able to do that when they don't have access to that information. And quite frankly, I mean, I believe at the sentencing hearing, the sentencing judge even made a no contact order with my client and these victims. So, I mean, especially when you have situations like that where the victim doesn't want to have anything to do with the defendant, it would put them in a very difficult position to be able to put on that kind of proof. So I think that's why we have the victim have to prove this up, because otherwise the defendant's in a very difficult position to get a hold of the information that would be required to otherwise combat that assumption. Does that answer your question, Your Honor? Maybe not sufficiently, but I think that's part of the reason why we start from that position. I think we'd like you, obviously, to uphold the Court of Appeals opinion. I mean, but really what I wanted to walk away with this morning was to say that the state's petition, I think, assumes that the Court of Appeals opinion goes farther than it really does. And I think when you reread the Court of Appeals opinion, I think it's pretty logical. It allows for the possibility that there might be lost profits. If there's proof of those, it just said that in this case there wasn't, except for the $70 that the defense attorney had stipulated to below. And so we would ask that that opinion be upheld.
Any further questions of counsel? Any further presentation? Thank you, counsel. Justice Lugar informs me that you reserve 2 minutes for rebuttal.
I think we disagree on what the Court of Appeals ruled in this case. I think the Court of Appeals said you could never get the retail price. And going back to my example, the Court of Appeals is saying don't look at the price tag for this item. You can't look at that. You have to look at the wholesale price. And that's where they went wrong. And Syllabus 8, in their opinion, basically says that. And I don't know how you can reconcile that with Syllabus 5, which says you look at what a willing seller and buyer would agree upon in an arm's length transaction. The person who wrote the majority opinion, the judge who wrote it in Hall, dissented in State versus Davis for that reason, I think, as far as this retail-wholesale difference. And while this case in the 609 letter, State v. Davis, says that you have to go with what the evidence that was presented. It can be contested by the defendant, as it was here, and we're going to leave it to the trial court's substantial discretion to look at what the restitution amount. And part of that should include that restitution, the purpose of restitution is to have a deterrent effect. Why should we reward?
Isn't the function of a restitution, I mean, the whole underlying function or purpose is to make the victim whole in some sort of fashion. And what we're trying to do is carve out some limitations or exceptions as to what it takes to get there. And my problem with these hearings is I did them. Some victims and prosecutors try to make them like civil proceedings. And you look at kind of damages as a result of the causation and go kind of far afield, and it really should be a matter of a civil case as opposed to a criminal case. And then you get some limitations that perhaps the Court of Appeals did here, that you can't consider certain evidence and certain values that would make the victim whole. And it seems to me that that's what the whole restitution statute's about, is the trial court's attempt, based upon the evidence, to put the victim where he or she was prior to the crime. Usually that's impossible, but at least some attempt to. And isn't that really the whole focus of this?
I agree with you on the part about civil damage issues don't apply, and that we want to restore and make the victim whole. Look at the Davis Court's distinction of State versus Hall and why we don't follow civil cases. But to reward a shoplifter by saying, okay, you don't have to pay the price on the price tag, you get the wholesale price for that, shows us that crime would pay. And there should be a deterrent effect also to restitution. I would ask you to restore what the law was before Hall. We're going to leave considerable discretion to the trial courts to determine this, and that there was not an abuse of discretion when the district court did that in this case. Thank you.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.